Dan, do you realize that when you read an apology letter at a sentencing hearing, that a judge is deciding?
We are on the record. We have everybody here, right? I'm not missing anybody, am I?
Correct, Your Honor.
Okay, we're on the record in case A21844-652C, Anna Echevarria versus Zaon Collins, and we are outside the presence of the jury. Counsel, why don't you go ahead and put your appearances on the record?
Ramzy Ladah for plaintiff.
Joseph Chu for plaintiff.
Stephanie Zinna for defendant Zaon Collins.
And Tyler Watson for Marvin Collins.
Okay, so we have a couple of issues that I think it makes sense to hear about or to discuss before we discuss jury instructions. So let's start with those. Let's start first with the, no, for the right thing, just a minute. Let's start first with the request we stopped with last night, the issues in the Justice Court case, and desire to discuss the positive drug test results that, if my documentation is correct, were on the record dated July 18, 2022. And there's two, isn't there? Are they all positive? I have records of July. There were two hits, weren't there?
Yes, Your Honor.
I'm sorry, I don't want to get the dates wrong. Give me just a second. Oh, sorry. May 31st, 2022 and June 14th, 2022. One of the issues raised in the moving papers was that the results were garnered, I think, a month or close to a month after the actual dates of removal too in the moving papers. Okay, my inclination is still the same to not include this, but I'm willing to let you guys make your record. And my inclination is there for a few reasons. I do think it's overly prejudicial. I am concerned about not just the validity, I mean, there's a lot of issues here with these drug tests. The experts, or I should probably phrase it more like the war of the experts responding to the same. There is a polygraph test in here and the results were the same. There's issues with whether the polygraph test is admissible because there was no stipulation to that. So I did review this, and I just am really hesitant to allow this to come in, especially because it's my understanding that it's coming in simply to impeach Zaon, to prove drug use. Is that what the intent is? Am I understanding that?
Yes, Your Honor, to impeach his statement that he doesn't do drugs.
Okay. So, counsel, do you want to make additional record, or do you understand why I'm not including it?
I do understand, Your Honor. I just briefly, just for the record, I don't want to waste time. This would be used to impeach Mr. Collins because he says he doesn't do drugs. He said it twice on the stand. Also, this needed to be disclosed, so at a minimum, if it was disclosed before the expert disclosure deadline with the entire criminal file, because it was my understanding they were disclosing the entire criminal file. I could have had my own expert take a look at this and determine whether or not this was valid. I've been prejudiced because this was not produced, and it was not produced timely, especially when they disclosed the criminal file. I asked numerous times to make sure it was the entire criminal file. My understanding is it was the whole criminal file they were getting from their criminal defense lawyer. That's all the record I need. Thank you, Your Honor.
Okay, let me ask you a question. Did this go to the toxicologist? Like, did you talk to the toxicologist about this last night?
No, I did not, Your Honor.
Okay.
I don't know why I would, because I can't get it in now through the toxicologist. I mean, I can't have him give me an opinion that can't get him back on the stand at this point. So at this point, it's too late, if that makes sense, Your Honor.
Yeah. Okay. Response.
Just very briefly, I As to the production, these tests, as I had stated on March yesterday, would not be in the criminal file anyway, because they are not part of what is given to defense counsel. And we did have a call with counsel to discuss that. Those are not typically handed over unless the state files a motion and then they're attached to the motion, so that would not have been there. So that would have been produced in a public record, in any production. But I agree with Your Honor that I think it's overly prejudicial in the ruling that you're giving on this unless you're intending to change it conforms with Lovato v. State as to extrinsic evidence to impeach. So I don't have anything.
May I say one thing, and it's not to change your mind, just to make sure I make my record, Your Honor, I'm sorry. I disagree with counsel's assertion that somehow this would not have been in the criminal file. These were attached to a motion that was filed in this case.
Oh, I'll tell you right now, I think this should have been in the criminal file.
Thank you.
Yeah, my position is this should have been in the criminal file. If someone's saying, here's my whole file from my other lawyer, now, every bit of it, who knows? But at the same time, the other lawyer hired an expert to respond to this, polygraph tests. Like, I feel like this, the state's motion, the state's notice of motion and motion to remand, the document filed on June 27, 2022 should have been in there. The document filed on June 28, 2022, about 2 days and 3 days. The document filed on June 28, 2022, the defendant's opposition should have been in the criminal file. The state's reply filed on July 6, 2022 also should have been in the criminal file. I will say though, you know, and I'm sure as civil lawyers you thought this too, reading them, getting motions and oppositions and replies that were 4 pages or less, God. Maybe we all should have practiced criminal law. Because they were a quick read last night. But yeah, I think this, I agree, this should have been in the criminal file, and it would have been, if I was in your shoes and someone said to me, I got the whole criminal, or here's the whole criminal file, I would assume this was in there too, and I wouldn't be going through it with a fine-tooth comb thinking things were missing. But I don't think that it not being a part of that file is enough reason to include it because of the overly prejudicial nature of it, because I'm not sure that this actually evidences, and especially because of the competing expert reports thereafter, that this actually evidences that he does use drugs. So I don't think it's actually proof, at least not definitive proof, because I think if it was, and I hate that I'm in the position I'm in, but I'm in the position I'm in with this, I think if it was, there might have been a different ruling by the Justice Court judge. Justice Court judge denied it. Unfortunately, we don't have an explanation as to why. That might have given us a little more light on this issue. But because of that, because we've also got the expert reports saying what they're saying afterwards, I just don't think it, I think it creates more questions here that would have us go down a full rabbit hole of more issues, and I don't want this trial to become that. So for that reason, I'm excluding it. I also believe that if your goal is to impeach him on that, I think you've got other things that you can use that are fair game, for lack of a better way of phrasing it at this point, in this trial, that either are already in evidence or that you could bring up with him when he gets back on the stand. Okay, so for that reason, this is excluded. Anybody want any more explanation at this time?
Not for Plaintiff, Karen. Thank you.
Anybody need me to make an actual formal written order on that at this time?
I don't believe so, Your Honor. I think we've made the record. I think
Okay, thank you. That's one less thing. Okay. Let's now talk about the 41440 issue from Mr. Watson.
Yes.
Yeah, go ahead.
Oh, I was just, I didn't know what you wanted to do. Did you want to hear argument on it? Did you want to talk about the procedural issues? What was the court's
If
inclination?
you want to put argument on the record more than what you've already done, you're welcome to do it. I know I cut you off last night, but my intent was not to not let you make the record you wanted to make. My intention was to to not continue to go in circles if we could avoid it, and because we're coming toward the end of the day. So if you feel like you haven't had a chance to make the record, or if you want to reiterate anything on the record, feel free to do so, and then I will make some comments, and then you can have you can respond if you want to.
No, I mean, I think the issue was adequately addressed with the brief and what Mr. Johnson had articulated in court a few days ago. So I believe it's properly submitted to the court for whatever decision the court wants to make on that issue.
Okay. Do you want to say anything on the issue, Mr. Ladah?
Regarding the constitutionality, I just wanted to make a record on the.
Yeah, I think the notice is done. I believe, I believe my ruling on the notice is clear, right? But if you want to say anything on the notice, I understand what you're saying, that it wasn't in certain things, but it was in the amended complaint. So I think the notice was there.
I appreciate
We
it.
understand your position, Your Honor.
And just for the record, Your Honor, our position is, agency or vicarious liability is not a separate cause of action anyways. Although it was amended, it was alleged in the amended complaint, it's not something that needs to be alleged as a cause of action, meaning it doesn't actually need to be stated in the joint pretrial memo. Even if I was wrong on that, we did not abandon it, as Your Honor pointed out. So defense was well aware of it and it's fair game. I'll just leave it at that, Your Honor.
Okay, constitutionality, and look, I did review Arata versus Fabian. Are you familiar with, the case I'm talking about?
It's cited in the.
Yeah, it post dates some of the ones you're citing that support your position. And it does state a couple things that I think are important. It's my understanding this is a situation of a 19-year-old that was held responsible, because I think one of the arguments you make in your complaint that there isn't a record of enforcing this when we're dealing with minors. Well, I think this case and the citation 123 Nevada 153 2007. The citation does say that this can apply when the driver, family member is and of adult age. And like I said, this case, I believe, was the driver was 19, very similar to our case in front of us where the driver was 19, right, at the time. Okay. This case does actually talk about the constitutionality issue too. And there's some clear language on that too, which I'm going to read in the record right now, but I'll still let you respond just a second. Let me find the language that I wanted to read. Talks about the standard because of the equal protection and constitutionality scrutiny, but before that, it even talks about, it says very clearly that it doesn't believe that this creates the issue that you're asserting that it does. Now, there is not a lot of explanation as to how it gets to that conclusion, and I understand it would be helpful if there were. Find it. Okay, it very clearly says, and like I said, I wish there was more explanation as to why, but I think this goes to your argument. And I am on page 159. Consequently, NRS 4.140 does not infringe upon a fundamental right. Moreover, NRS 41440 affects no discrimination against a suspect class. So I understand your argument. I think you're making the opposite argument, right?
But it does.
Yeah.
Yes.
And look, like I said, I wish there was more description as to how they came to that conclusion, but I think this conclusion completely belies the argument. No?
No, I would disagree.
Go for it.
But, obviously appreciate the court's position on it. But the 3 points that I would raise in response was, first, in the Arata matter, age wasn't part of the appeal. It wasn't raised. So yes, I agree he was 19, but we also have the case from 2001, which says the exact opposite. And
But that predates this, 2007
correct,
is this
but
one.
there has not been any material change to the statute in between those two cases. And so we have these conflicting issues where both rulings are essentially not addressing the heart of the issue. So in the Arata
Doesn't the
matter,
later case dominate then? The most recent case dominates?
Well, not if they're not actually addressing the issue. So they're only going to address on appeal something that was raised to them. So going back and looking at the appeal, age wasn't raised. Also, members of a suspect class were not raised in the errata matter. So given that ambiguity, we think it would be appropriate for the Supreme Court to take another look at it and articulate their clear position on that issue. Next, in the errata matter, the standard was rational basis because what they were appealing was the constitutionality of holding a non-negligent family member liable when they weren't involved. This is a different argument that we believe would change the standard of review to strict scrutiny because of the way it disproportionately affects families of color. And then finally, Your Honor, as I already began to articulate, since we do have the 2001 case, the Borgenson case, where the court expressly says that they have not allowed this to be applied to adults, and then they cite NRS 41440. We think that there's a sufficient basis for this to go up on appeal, given the court's inclination. But that's our position, and I appreciate where the court is as well. Thank you, Your Honor.
Okay, I don't think if I haven't already responded to any part of that, but I think I've responded to every major part of what you just said. Okay, anything else on that issue?
Not for me, Your Honor.
I do think, and I did look a little bit at 41440, and I think the intention, and that case talks about it, and a few of the other cases talk about it too. The intention is that, you know, as a family member, you're supposed to be in a better position to be aware of your family member's history and condition and so forth. So I think that's part of the intention of 41440 as well. But I understand the concerns. I just disagree with you. Okay.
Understood. Thank you.
Okay. Before we get to jury instructions, anything else or any other issues that anybody wants to flush out, to argue, to make a record of?
There's an issue for Mr. Zaon Collins when he testifies, Your Honor, but I don't want to rush the subject. So just before he testifies, I'd like to I'll bring something up.
When's he gonna be here? 12:30?
Oh, yeah.
Okay. So why don't we bring it up now?
Sure. I have two concerns with Mr. Collins. The first would be anything that elicits sympathy or the only purpose of the testimony or the information would be to elicit sympathy. Getting in details on his background, his family relationship, any of those things would be just to elicit sympathy. Also, anything about how this case has affected him, because he's not a claimant here. He doesn't have a counterclaim for damages. So anything that way the case has affected him is not relevant in this stage of the case, the compensatory damages stage, Your Honor. And that would be inappropriate, to be prejudicial to the plaintiff. Also, anything concerning his financial condition, what he can or cannot afford, that all goes to the collectability. It's improper for him to talk about any of that in this stage of the case. So any testimony that touches on those areas, I am going to be objecting, and I think it would be inappropriate, to be prejudicial, and I think it irrelevant to the issues that the jury in this stage of the case is supposed to address, which are liability and plaintiff's damages.
Is there an intention, before I let you respond, because if there isn't, then I think that this makes this a little shorter. Is there an intention to ask questions that do that for that purpose?
And Your Honor, I don't believe that my questions that I have outlined weighed into that. But if this was really a concern by plaintiff, he could have filed a motion in limine on this. You know, he's welcome to object if he thinks my question goes too far, but I don't have an intention to wade very deeply into any of those subjects, if at all.
You want to respond at all?
Yeah, and sorry, there was one other thing, Your Honor.
No, do you want to respond to what she said before you say anything additional?
Oh, okay, thank you. Based on that, I guess I would just have to object contemporaneous with the questions if I think they're inappropriate.
Yeah.
Or move to strike the answers if I think they delve into those areas. But obviously, I'll give my trust in defense counsel and hope that, she's not gonna delve into those areas with her questions.
Okay. Next thing then. that
Next
you
thing would
remember.
be, it would be inappropriate, Your Honor, for Mr. Collins to try to say something to my client, Ms. Echevarria, while he's on the stand. So any questions that would ask him, is there anything you want to say to Miss Echevarria while she's sitting here? I think that would be inappropriate, Your Honor, and I think that would be prejudicial.
Were you gonna ask him that? Is there anything you want to say to Miss Echevarria?
I wasn't going to ask him that. But they've made a very big deal, and I'm sorry, do you mind if I sit, Your Honor? I'm not feeling.
No, I
effective.
think everybody should stay sitting in here
Thank
because
you.
the microphones are better. It doesn't bother me in the least bit.
I appreciate it. They've made a big deal out of Zaon not apologizing, which he has done so multiple times. But other than that, no, I don't have any intention of saying, do you have something to say to Mrs. Echevarria?
You don't need to have any intention of asking that.
No,
Okay.
I don't believe it would be inappropriate, but I don't have any intention, so it's moot.
Okay, well, if she's not gonna ask it, then I don't think it's an issue either.
Thank you, Your Honor.
Okay, anything else before we I give my staff a break before we get started again?
No, Your Honor.
Really quick and easy, Judge, we have a few trade outs, there was
Any
a,
instructions?
on.
Looks like exhibits.
Exhibit 7, yeah, I'm gonna approach.
Okay,
counsel
you
here.
guys already have these.
No,
I'm
Do
handing.
you want to do it on the record or you want to talk to each other and then make a record?
can we have a moment to look and
Yeah,
compare?
well, yeah, we need to take your break.
Well, we had sent these over via email, I should have said.
Okay, let me let my staff go to lunch.
Yeah, no
So we'll
problem.
go off the record. You guys can do whatever you need to do. And then when we come back on, you can make a record. And also when we come back on, if defense is done, I need you to rest, okay?
Understood. Thank you, Your Honor.
Right, and just, yeah.
This is off the record right now.
Well, just for scheduling, Zaon will be quick and we're done.
Okay,
So-
then I'll give them their break and we'll see how much we can get done, or if I need to send them home or not.
I would
I want-
really prefer it if we could get jury instructions done. I think we only have about 14 left and I think we could get through it if we gave them just said, hey, give us a 30-minute break and we'll get you done today.
So no mom,
Well, it depends, but probably not.
possibly mom.
Possibly Mom, but probably not.
More likely than not, Stan.
Hey,
More
but
likely
it-
than not.
I mean, it's,
That's all that you need here.
if you needed to call her, she would be here though, or.
She's here.
Okay.
Jury. Back on the record, case A 21844652C, Anna Maria Echevarria versus Zaon Collins. Have the jury ready to go. Counselor ready. I did take a look at the jury, everybody can say seated. Oh, do you want to make a record? Go ahead, let's say who's here.
Ramzy Ladah for plaintiff.
Joseph Trooper, planning.
Stephanie Zinna for Defendant, Zaon Collins.
And Tyler Watson from Marvin Collins.
Okay, so, get everybody on the record. I do not think that it's realistic to read the jury instructions today unless we're gonna take about an hour break after everybody's case in chief is done, because I think we have too much work to do, and I'm a little bit concerned about the verdict forms too, and I actually have some questions for counsel on them. We can do the best we can to try to get there and get everything done. Realistically, do you anticipate rebuttal? Or do you not know yet?
Am I closing?
No,
Oh.
after they rest.
I would say likely not, Your Honor, but very slim possibility.
Okay, then here's what we'll do. After you rest, if there's no rebuttal, I'm gonna release the jury and I'll tell them that that's their afternoon break. If it's reasonable time, if it's already like 4 o'clock, I'm just gonna send them home and tell them to come back on Monday at 9 o'clock. Actually, I'm gonna tell them 9:15, just in case we have anything. But if it's earlier than 4 o'clock, I'm gonna let them go for 20 minutes, and we're gonna see what we can get done. But realistically, I don't know how we get a final set with the law taken off of it, with no references to law firms, with everything included in a order that will make some sense today, because I don't think that's a 20-minute thing in the status, at the status we're currently at now. Council are a lot more prepared than I think, and you guys actually do have like them all put together neatly and in an easy way to understand, and you feel otherwise, we'll discuss it during that 20 minutes, but what I'm probably gonna do is I'm gonna give them a 20-minute coffee break, I'm gonna bring them back in here. I'm going to just confirm where we are and tell them that we're gonna bring it back in on Monday. But that's what I anticipate. Does anyone have any questions about that process or how that's likely gonna go?
My only preference is because we're gonna be so short today on witnesses, that they came all the way down here for one witness, and that's just, I hate that. But we have 14 jury instructions left, I think. If it were going to just be a little longer than the 20 minutes, we could ask their preference if they'd rather just stay for a longer break and then come back and then get the instructions read. And then if they're like, no, I'd rather bounce out of here early on a Friday, I completely understand. My concern being that once we get them settled and reading, I don't want to put us into a position where we're crunched for time on Monday either. But again, I wanted to express that concern and see if there is anything that we could do, and we can engage that later.
Okay, well, look, time situations end up being what they are, and we have to work with what we have, you know. Part of the issue with that is because certain witnesses were not available on certain days. And that's out of my control. No matter what I can do about that, I can't, well, I can order people to be here. But as far as the parties go,
No, I understand, and so if we do just have the one witness today and plaintiff does not call a rebuttal, maybe just an instruction, thank you for coming in, we know it's a short day. We have to, sometimes we have to deal with that kind of thing, just so it doesn't appear like, the defense turned all of them back in for 30 minutes. That's my only preference.
what are your thoughts on that?
I just don't want the court to be rushed, Your Honor. And I would be shocked if we don't get closing done on Monday. I mean, I've never gone over a day in closing, not to say that it can't happen, but I'd just be shocked if we don't get it done on Monday. So even with reading the jury instructions, I don't want the court to be rushed, of course, Your Honor. So it's up to you.
I think the instructions are of such importance that I don't want to put them together in a hurried way. And I want to make sure that both of you have the time to look at what we're reading and the order in which we're reading it and break that down. And I think the best way for us to do that is for everybody to close their cases today, if everybody can do that today. And then we go through everything. We maybe take a break and put together the final set, print it out. Everybody has a little bit more time to look at the final set. And by the time we leave here today, everybody knows what the final set is, what the order of that set's gonna be. And so there's no confusion versus if we try to put this together fast for the jury, I think it's gonna be hard. But let's see how far we get and how long things take. Because look, if Zaon's on the stand for 3 hours, this is a different situation.
And he won't
You know, okay.
Right, so that's the.
Let me tell Greg that we're ready to bring him in, okay? That I am correct, that the only thing we have left that we haven't already done, jury instructions and verdict forms, right?
Yes, Your Honor.
Okay, and actually, let me just give, well, we'll talk about it in a minute. Okay,
And a few exhibit swap outs, Judge. That's it.
okay,
Perfunctory.
that's fine, as long as that's done before as long as it's those are gonna be via stipulation, right?
Correct.
Okay. Do you guys want to do that now before people walk in, or actually, let's get them going? Okay, let me text Greg and say we're good to go. Oh, he saw me. Okay, thanks. As he's lining them up, I just want to confirm, it is my understanding that you are resting plaintiff's counsel and that you two have an agreement as to what can be asked of Zaon on the stand as a result. Is that correct?
I believe so, based on discussions in the courtroom.
Okay.
Thank you. The council can all the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
We do.
Thank you very much. Everyone can please be seated. Ladies and gentlemen, welcome back. Really appreciate again how timely you're being and how attentive you've been throughout the trial. With that being said, plaintiff's counsel, do you rest your case in chief at this time?
Yes, Your Honor, we rest our case in chief.
Okay, defense counsel, are you prepared to call your first witness?
Yes, Your Honor, we are. The defense calls Zaon Collins to the stand, please.
Go ahead and raise your right hand and my clerk's gonna swear you in. Just a second.
solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Please state, spell your first and last name for the record, please.
Zaon Collins, Zaon Collins.
All right, good afternoon, Zaon.
Good afternoon.
How are you doing?
I'm good.
Finished with finals?
Yeah,
All right.
Yeah.
How do you think you did?
I think I did good.
Good.
Yeah.
You're currently a student at Fresno State?
Yes.
And what year are you in?
My junior year,
What are you studying?
uh, PR and advertising, public relations and advertising.
What are you planning on doing with that degree?
Objection relevance, Your Honor.
It's just establishing some background information on Mr. Collins and what he plans to do with his degree.
Okay, but how there's no relevance here. How is that relevant to this case?
I believe it's relevant because it establishes some background information as to Mr. Collins. However, that's fine. I'll move on.
Okay, sustained. Thank you.
All right, Zaon, I want to move on to the day of the accident. Okay. Where were you heading?
I was heading to basketball practice.
And can you take us through what happened a little bit as you left your mom's house?
I was driving, and I forgot what the road is called,
Fort Apache?
Fort Apache. And it was one lane going that way and one lane coming towards me, and then it breaks off the two. So I was like getting into the right lane, and Mr. Eric car, it was a car in front of me to the left, and Mr. Eric he flinched, go in front of him, which made the car in front of me go into the not swerve really, but just go around. And that's why I thought Mr. Eric saw me, but he didn't see me, and he just cut right in front of me. Yeah.
All right. And then what happened as he cut in front of you? What happened?
I tried to avoid I tried to avoid him.
Did you slam on the brakes?
Yes,
Did you swerve?
yes.
And after the crash, do you recall what you did?
Yeah, I got out the car. I checked on Mr. Eric. And that's pretty much it. I don't remember.
Okay. And you stated that you thought Mr. Eric had seen you coming. What made you think that?
I mean, because the car to the left of me, when he flinched in front of him, I'm in the right lane, right behind him. So I mean, it wasn't raining or nothing, so I just thought he could just see me coming. Yeah.
Okay. All right. So you made the assumption that he had seen you and you kept driving.
Yeah, yeah, because he shot out there.
After the crash, you went over to check on Mr. Eric, is that right?
Yes.
And do you remember anything after that?
No.
What's the next thing you remember?
really been in the detention center.
You had a criminal attorney represent you in that matter, correct?
Yes.
What was his name?
David Chesnoff?
Is he affiliated with my office at all?
No.
Were you aware of him saying anything negative about the Echevarria family?
No.
Do you recall saying anything negative about the Echevarria family yourself?
No. I tried to apologize like a lot, many times. Yeah.
You're still currently on probation for your convictions, correct?
Yes.
Objection relevance, Your Honor.
He talked about, they talked extensively about his criminal convictions and the sentencing yesterday on Anne
The
Marie's.
door was open,
Correct.
overruled.
Thank you. You were still on probation for this conviction, correct?
Yes.
Do you know when you're going to be released from probation?
I'm not sure the exact date.
Do you know how much longer you have left?
No.
That's okay.
Yeah.
Have you been on monitoring ever since this accident?
Objection relevance, Your Honor.
Once again, they opened the door on,
May we approach, Your Honor?
Yeah.
right, Zaon, as part of your probation terms, you're required to follow your rules and regulations, correct?
Yes.
Thank you. In the past, have you apologized to the family?
Yes. A lot.
Okay, have you ever tried to talk to Anne Marie?
Yes, I have.
Were you able to talk to her?
No, I would never been able to talk to her like directly. We've tried to talk to her directly, but um it was just like the way that she would um the way that she like used to come at me.
Objection, Your Honor. This is prejudicial at this point. I just move to strike.
I don't have an objection to striking that.
Okay, so we'll strike that and move on, please.
Okay. All right. So in the past, you have tried to talk to Anne Marie, it didn't work out. Is that what you're telling?
Asked and answered, Your Honor.
Sustained.
All right, Zaon, but you believe that you have apologized multiple times in the past.
Objection asked, answered, and leading.
Sustained.
Zaon, is there anything else that you wish to say today to the jury?
Objection vague, Your Honor. Irrelevant.
I don't know what the response is gonna be, so I don't know if it's really relevant. Without giving me the response, do you have a response to his objection? That would be appropriate to say not at the bench. If not, then approach and let's hear what the response is gonna be.
I can ask the question a different way,
Okay.
and then maybe we could just resolve that without going to the bench. Okay. Zaon, you've stated before that you're taking responsibility for your part of this crash, is that right?
Yes.
And does that still stand right now?
Yes, it does. It still stands. I take responsibility for my part, and I'm sorry that it happened. But
Thank you. Nothing further.
Okay, hold on. Mr. Watson, do you have any questions for this witness?
No question, John.
Okay. Mr. Ladah.
Thank you, Your Honor. Court's indulgence, Your Honor. Good afternoon, Mr. Collins.
good afternoon.
Earlier you just said how you recall the crash occurring. Remember saying that?
Uh, Yeah.
Do you remember what you said in your interrogatory responses about how the crash occurred?
No. Yes.
Let's
Was
go over that.
Sorry, was that a no or a yes?
Um, can I see it?
Yeah, I want to go over with you. Is that okay?
Yes.
Thank you. May I approach, Your Honor?
Yes.
I only have 2 copies.
Then you can.
I'm gonna wait for you to pull it up, Stephanie. Okay. If you can go to page 5, if you don't mind, please. It's okay if I just call you Zaon? Is that all right?
Yes.
Okay, thank you. Tell me when you're there.
I'm here.
And your answer starts at line 17. The lines are on the left-hand side. You see that?
Yes.
Okay. Says, I was coming from home and heading to basketball practice at the Las Vegas Basketball Center near Tenaya and Regatta. I intended to take Fort Apache to the 215. From home, I took Quarter House to LeBaron to Fort Apache. There is no stop sign as Fort Apache crosses Gomer. I cross Gomer and North Fort Apache changes from 1 lane to 2. South Fort Apache was 1 lane. I was in the right lane and another car was ahead of me in the left lane at about the same speed. I saw Mr. Echevarria's car going down South Fort Apache, stop to make a left turn into a neighborhood. Mr. Echevarria tried to go in front of the car in front of me, then stopped. He then made a left turn in front of me. I didn't expect him to make a left turn because he saw the car in front of me. I hit the brakes but was unable to avoid the accident. I believe Mr. Echevarria is to blame because he had made a left turn in front of me. Did I read that correctly?
Yes.
Did you blame Mr. Echevarria in that response?
Well,
Just a yes or no question. Yeah. Did you blame Mr. Echevarria in that response?
for cutting in front of me.
Did you say you were taking responsibility for this crash in that response?
No.
You realize those responses were under oath.
Yes.
Thank you. All right. Earlier, when defense counsel asked you what you did to avoid this crash, you said you swerved. Do you remember that?
I don't remember.
You don't remember her asking the question and you answering saying you swerved? Or you don't remember swerving?
Yeah, I do remember her asking.
Are you saying you don't remember swerving?
I never said that.
I'm sorry, I apologize. I thought I heard you say I don't remember. I'm just trying to figure out what you were referring to when you said I don't remember.
The question until you said the second part.
Okay. All right. Do you remember what you said about that, what you did to respond to this crash in your interrogatory responses?
Can you say that again?
In your interrogatory responses, you were asked what you did to avoid this crash. Do you remember what your answer was?
No.
Let's go to page 12 of your ROG responses, please, Zaon. And the question is actually on page 11, and I'm going to go on to page 12 for your answer,
Okay.
if you want to follow along. And it's under where it says interrogatory number 12, or sorry, interrogatory number 10. And then the answer is on page 12 in bold at the top, okay? Just so you can follow along.
Okay.
Okay, so I'm reading the question first. It says, explain what evasive maneuvers you took, if any, to avoid the subject collision in the minute leading up to the subject collision. Explain why you took those evasive maneuvers as opposed to other evasive maneuvers. Answer. I hit the brakes to try to avoid the accident. There was no time to take any other evasive maneuver. Did I read that correctly?
Yes.
Did you say anything in there in that answer about swerving?
No.
Okay, thank you. Dan, do you remember in your deposition when you said you don't remember this crash very well?
No.
You don't remember saying that?
No, I don't remember saying that.
Okay, no problem. Dan, you would agree it is reasonable for drivers to expect other drivers on the road to drive at a reasonable speed?
Yes,
Do you have your deposition there with you?
I do.
Okay. Is it on, it's on the table or where is it? Oh, not the interrogatories, the deposition.
Yes.
Thank you. I want you to go to page 58 for me, Zaon, if you don't mind, please. I'm gonna read through the top of page 60, okay, if you just follow along. It's starting on line 22 of page 58. You tell me if I read this correctly. You there?
Yes.
Great, thank you. Question, okay, you agree that when someone is driving and going to turn left, cut across traffic, they have a reasonable expectation that the cross traffic, which is you, answer yeah. Question, are going to be following the speed limit and not driving above the speed limit? Answer yes. Question, you agree? Answer, I agree. Question, okay, so it was reasonable for him to expect that you would be following the speed limit? Answer, yeah, yes. Question, okay, thank you. If you were not going the speed limit, you were not going to get to the intersection faster, you agree? Say that again. Okay, if you're going slower, you're going to get to a location slower. If you're going faster, you're going to get to a location faster on the road. You understand that, right? Answer, yeah, I understand that. Question, okay, so if you were going the speed limit, he would have had more time to get through the intersection and finish the left turn. You understand that, correct? Answer, I understand that. Question, okay, so if you were going the speed limit, he likely would have made it through his turn and the collision never would have occurred. You understand that, correct? Answer, I understand that. Did I read that correctly?
Yes.
That was your under oath testimony, correct?
Yes.
Are you changing your testimony today?
No.
Thank you. I want to talk about the apology for a second, okay?
Yes.
You said you apologized to the family.
Yes.
Okay. You did that when you were in court for the sentencing, correct?
And other times, yes.
Okay. When you were in court for the sentencing, you read a letter, correct?
Yes.
Okay. You knew that Anne Marie was not in the courtroom when you read that letter, correct?
I thought she was going to be there, but she didn't show up.
But she was not there, correct?
Yes.
You could have mailed that letter to Anne Marie, couldn't you have?
I believe that I wasn't supposed to have any direct contact.
Who told you that?
I'm not sure, but I heard it a couple times throughout my criminal case.
Are you aware that your probation says nothing about direct contact with Anne Marie?
It wasn't, I don't believe it was to do with my probation.
Yeah. Did you ask if you were allowed to mail a letter to Anne Marie?
Objection. Most for speculation lacks foundation. Vague.
Response.
Simple question. I don't think it's vague, Your Honor.
I don't think it's vague either. The other reason was lacked foundation.
Most for speculation lacks foundation. Did he ask who? Who would he have asked?
Overruled. You can ask the question.
Say it again.
Did you ask the judge or the prosecutor if you are allowed to mail an apology letter to Anne Marie?
I just remember I was told that I wasn't allowed to have direct communication with them, but I did not.
And you don't remember who told you that?
No, either the judge or like a lawyer. I'm not sure.
But you never asked anyone and said, hey, I'd like to send an apology letter to Anne Marie. You never asked anyone if you could do that.
Shouldn't ask and answered, argumentative.
Overruled.
Can you say it again, please?
You never went up to anyone and said, hey, I really want to send an apology letter to Anne Marie for what happened to her husband. You never went up to anyone and said that, did you?
I said I want to meet with her in person and sit down and apologize. I never said I don't want to write a letter. I wanted to see her and apologize.
So you asked if you could meet in person, but you never asked if you could send a letter.
Yes.
Thank you. Now, the apology letter that you read, that was at the actual sentencing hearing, correct, Zaon?
Yes.
You realize at that point, the judge has the discretion to decide what sentence to impose, correct?
Action, Your Honor. Relevance, calls for speculation.
I can ask it, where are you aware? If I may, Your Honor. Dan, do you realize that when you read an apology letter at a sentencing hearing, that a judge is deciding what sentence to impose on you, that can influence the judge to decide whether or not she wants to influence a harsher sentence or a more lenient sentence? You realize that, right?
Yes.
Thank you. And you realize what you were pleading guilty to when you pled guilty, correct?
Yes.
Thank you for your time, Zan. I appreciate it.
Any additional questions?
Yes, Your Honor. Okay, Zan, I want to go back to your interrogatories.
Okay.
Okay, let's talk about that interrogatory number 10, please. Where you said
This one?
you had no time to take, yeah, that one. Sorry, hon. You had no time to take any other evasive maneuvers. As we were able to get more information through the discovery of this case and expert opinions, you do now know you swerved to the right.
Yes.
Objection pleading, Your Honor.
Sustained.
Did you swerve to the right after after you saw Eric cut in front of you?
Yes.
And could you please go to interrogatory number 12? Jurani, do you have that pulled up for me? Sorry. You could go to number 12, please. And in your answer to interrogatory number 12, do you see at the very bottom there? You stated, I do not believe I am 100% responsible for the accident. Mr. Echevarria made a left turn in front of me, which caused or contributed to the accident, correct? Do you see that answer?
Yeah.
Did you intend in answering legal questions to not take your responsibility for your portion of this accident?
Can you say it again?
In responding to legal questions in a document posed to you, did you intend to not take partial responsibility for your part of this accident?
Objection, Your Honor. He already stated earlier, doesn't remember responding to these interrogatories.
Your Honor, now that he's had a chance to look at them and refresh his recollection, I think he can answer the question.
Do you remember responding to the interrogatories? It's just a yes or a no.
Yes.
Okay. Go ahead, counsel.
Thank you. When you were responding to these legal questions that were posed to you, Was it your intention to state that you weren't at all at fault for this accident?
Objection to the term legal questions, interrogatories I don't believe are legal questions, Your Honor.
Okay, can you rephrase, counsel?
Sure, when you were objecting to these questions that were posed to you,
Objecting, responding.
oh, I was just moving on. I thought you sustained it.
Oh, no, I said rephrase, please.
Rephrase, yes, that's what I was trying to do. I
No, but you
apologize.
said when you were objecting to these questions that were posed to you, was that your intention? Or were you saying when you were responding to these questions that were posed to you?
Oh, thank you. I'm sorry. Yes, I apologize. I misspoke. When you were responding to these questions that were posed to you, did you have the intention to state that you were not at least partially at fault for this accident?
I said I was partially at fault.
All right. And then, you read your deposition with counsel, correct?
Yes,
You heard him ask you about that deposition testimony?
yes,
Okay, and in that deposition, you took responsibility for your part of speeding, correct?
yes,
In your and I apologize, I'll rephrase. In your deposition, did you take responsibility for your part in speeding?
yes,
And that was the part that was read to you by counsel?
yes.
That was your intention during that?
Your Honor, every question is leading at this point. This is a problem. It's not an adverse witness.
Sustained.
Was it your intention during the deposition to take responsibility for your part of this accident?
Yes,
And did you say you were sorry before you were sentenced? Do you remember that?
I did many times before that.
Well, no, I meant at that hearing. Do you recall whether or not you were sentenced first and then said you're sorry, or is it the other way around? Were you sentenced first and then read your apology? Do you recall?
I don't.
Okay, that's okay. Did you read that apology to influence the judge?
No, I really meant it.
Right, nothing further.
Mr. Watson, any additional questions?
No, Your Honor.
Mr. Ladah, any additional questions?
One brief follow-up, Your Honor, if I may.
Yes. Jurors, also, you will have the opportunity to ask this witness questions. I know you didn't have the opportunity last time he was on the stand, but you will have an opportunity this time. Because after the council finishes this time, they will have completed their questioning of this witness. So that's why you weren't allowed to ask questions last time this witness was on the stand.
Zan, can you look through your interrogatory responses and see if you apologized anywhere in there?
This one?
Yes. I didn't see an apology, but I want to give you the time to look through and tell me if you apologize anywhere in there. Just your interrogatory responses.
Oh, how do I find those?
These are, it's this one.
Yeah.
Yeah, it's just all the responses. You can look through. Take your time. To make it easy, you just look for the bold is your
Yeah,
response.
that was my question.
I'm sorry?
So that was my question at first.
Oh, okay.
Yeah.
Yeah, if you just focus on the bold, that's the easier part because that's your answer.
No.
Thank you. Thank you for being here, Zaon. I appreciate it.
Okay, any additional questions?
I actually don't think anything else is necessary at this time. Thank you.
Any additional questions, Mr. Watson?
No, Your Honor.
Okay, so at this time, if any of the jurors have questions for this witness, one question per page, please. Write your question as clearly as you can, because I'm gonna read it exactly as written. And then put your badge number on the top of the page and pass it to my marshal. Thank you. Thank you. Yeah. You found all of them? Okay, are there any more, or is anybody still working on one? If so, please raise your hand. See any hands raised, Mr. Chu? Okay, thanks. Okay. So I didn't get any objections to any of them. I'm gonna ask in the order I think I received them, so I'm going to just read them exactly as written, okay? And you don't have to look at me when you answer them, you can look at them since it's their question, okay? But I won't find it rude, I'm just gonna ask the question.
Okay.
Clarification for Mr. Collins, when you change lanes at the intersection, was it to pass the white SUV ahead of you or avoid colliding with the white Hyundai?
Huh?
I can read it, but I have to read it exactly as it's written again.
Okay.
I'm gonna read the whole thing again. That's
Okay.
what I'm supposed to do.
Okay.
Clarification for Mr. Collins. When you changed lanes at the intersection, was it to pass the white SUV ahead of you or avoid colliding with the white Hyundai?
I really just switched lanes just to do it. I wasn't trying to pass anyone or
Okay, next question. Why were you speeding that day?
I just lost track of like the speed. I just didn't know I was going that fast. I was just driving and I apologize for that.
Is your normal personality and temperament very laid back, or would you consider yourself very outgoing and talkative? Please explain.
I'm just very laid back. I'm like introvert. Don't be around a lot of people and that's just I'm just laid back, I guess you can say.
Okay. Are you finished with the answer?
Yes.
Defense counsel, do you have any additional questions for this witness based on those questions? Mr. Watson? Okay. Mr. Ladah, any additional questions for this witness based on those questions?
No, Your Honor, thank you.
Okay, do any of the jurors have any additional or follow-up questions? If you do, please raise your hand so I know you're writing. Okay, seeing none, we'll move on. Okay, thank you very much, Mr. Collins. You can go
Thank
ahead and go ahead and step down. Okay. Does defense have any more witness, does counsel for Zaon Collins have any more witnesses at this time? Okay, do you rest your case?
Yes, Your Honor. You're right.
Okay.
Defense record.
Mr. Watson, do you have any witnesses to call?
No, Your Honor.
Okay, Mr. Watson, do you rest your case?
Yes, Your Honor.
Okay. On behalf of Mr. Marvin Collins, do you rest?
Yes, Your Honor.
Plaintiffs' counsel, do you have any rebuttal witnesses to call at this time?
No need for any rebuttal witnesses, Your Honor.
Okay. So at this time, I'm going to give you all your afternoon break. I'm going to give you 20 minutes and ask that you please come back at 1:55 p.m. You can just go back in the back room. Don't come up and line up. Just go ahead and hang out in the back room at 1:55. Okay, I got to read you your instruction. Sorry. You're instructed not to talk with each other with anyone else about any subject or issue connected with this trial. Oh, hold on. Before we do that, does plaintiff rest their case?
Yes, we rest our case, Your Honor.
You're instructed not to talk with each other with anyone else about any subject or issue connected with this trial. You're not to read, watch, or listen to any report of or commentary on the trial by any person connected with this case or by any medium of information, including without limitation, newspapers, television, the internet, or radio. You're not to conduct any research on your own relating to this case, such as consulting dictionaries, using the internet, or using any reference materials. You're not to conduct any investigation, test any theory of the case, recreate an aspect of the case, or in any other way learn about the case or investigate the case on your own. You have to talk with others, text others, Google others, tweet, Google, or conduct any other kind of book or computer research with regard to any issue, party, witness, or attorney, or anyone else involved in this case. You don't have to form or express any opinion on any subject connected with its trial until the case is finally submitted to you. Just before I have you walk out of the room, I want counsel to please approach because I have a question for counsel that might affect your break. Okay, actually, in light of some of the discussions we just had at the bench, things that we need to take care of. The next step in this case is I read you the instruction on the law and I read you and we get to closing arguments. However, we have to take care of some stuff that has to be done outside of your presence first. And I'm a little concerned those are going to take more, that's going to take more than 20 minutes. So we're going to release you for the evening and ask you to come back at 9:15 on Monday, with the expectation that on Monday, we're going to go to reading the instructions and closing arguments. And with the hope that you will be deliberating by Monday afternoon, okay? Believe it or not, this is moving at a good pace. And we do still anticipate that we will not need you on the 23rd, and we're hoping we won't need you even on the 22nd. Okay, so with that being said, I have read you your instruction and we haven't done anything else since then. So I'm going to go ahead and release you for the evening. Leave your notebook behind. And like I said, on Monday, we plan on you coming in and doing, reading the instructions and going right to closing argument. So please, over the weekend, do not violate any of the instruction I just read to you. We'll see you 9:15 Monday morning. All right, everybody can go ahead and be seated. Do council want to take a brief break before we move on to any post-case in chief motions? Let's say it that way, just so we cover everybody's.
I would love to.
Okay, so let's take 15 minutes for us. It'll give my staff a little time too, because they've all had shortened breaks today. And I'll see you guys back in here at 2 o'clock, okay?
Yeah.
Can I get somebody to, I need to use.
218-44652C, Anna Echevarria versus Zaon Collins. Can counsel, we are outside the presence of the jury. Can counsel just go ahead and make a record of their appearances?
Ramzy Ladah, plaintiff.
Joseph Chu for the plaintiff.
Stephanie Zinna, Paterno, Jurani for defendant Zaon.
Okay, so this is the time. Okay. This is the time for any motions before we start to discuss, well, actually finalize jury instructions and get to closing. I did receive a motion on order shortening time in my inbox from defense counsel Zinna. Am I saying have I been mutilating your name this whole trial?
It's okay, everybody does, but it's Zinna.
Zinna, okay. From defense counsel Zinna, yesterday evening, I believe. And it was a request on OST to file an amended answer to the amended complaint. Is that correct?
That's correct.
Okay, do you want to make a record of it? Has opposing counsel seen this?
I believe if they haven't, my assistant will be emailing them shortly, so if we want to wait until they see it, but they were CC'd on it, okay. But I will turn that over to Mr. Jurani to make that record.
Okay, why don't you go ahead and make the record? And then I have a couple of questions. And have you seen it or no?
I personally have not seen it.
Let me check the inbox and I'll just print it from there, because I can't print it when they come in through the, I can't print it from the DC-11 inbox, but I can print it from the email inbox. And that'll actually tell me too, more exact time of when it was submitted.
Look at it online, Your Honor, so you don't have to print it.
It was sent at 5:53 yesterday.
Okay, 5:53. Does anyone want to print it? It's open right now and I can print it.
No, it's fine, it's fine. We can just look at it. Yeah.
Okay, so take a look at it, and while you're doing that, Miss Jurani, why don't you make your record?
Okay, if I sit, Your Honor.
Sure, just stay near your mic.
Is that okay? Yes, Your Honor. As you know, on May 9th, opposing counsel mentioned for the first time that an affirmative defense had not been pled in the answer of defendants regarding comparative negligence or contributory negligence. We're moving pursuant to NRCP 15B to amend the answer to plaintiff's amended complaint to include those affirmative defenses. NRCP 15B1 reads that the court should freely permit an amendment when doing so will aid in presenting the merits and the objecting party fails to satisfy the court that the evidence would prejudice that party's action or defense on the merits. It's our position, Your Honor, that plaintiffs have been well aware of the affirmative defense of comparative negligence since early in this action. It will clearly aid in presenting the merits and it would not prejudice plaintiff's claims. As early as July 15th, 2022, defendant Zaon Collins responded to plaintiff's request for admissions. Request number 16 asked admit that defendant Eric Echevarria did nothing to contribute or cause the motor vehicle crash on December 30th, 2020, to which defendant Collins replied, denied. On June 3rd, 2024, defendant Collins served supplemental responses to plaintiff's interrogatories. There are in seven of the responses to the interrogatories is made mention of that Mr. Echevarria made an unexpected left turn in front of Mr. Collins, and that Mr. Collins is alleging that is an affirmative defense of comparative negligence. In fact, I believe, well, I don't know if you want me to, I had cited all of these instances. I don't know if you need me to read them off.
Well, let's see what opposing counsel's response is before we go into too much detail, because maybe we don't need to be that detailed at this time yet. But before I do that, Mr. Watson, what's your position on this?
We join in the motion, Your Honor. We believe leave to amend should be granted.
And if I may, Your Honor, this was because we just wanted to make sure that we had a record on that we moved to amend, even though you've already issued your ruling. We just didn't want to create a weird appellate issue on it. So this was in no way requesting you to keep analyzing it or.
Well, here's the issue, and I'm happy to hear from you guys too first, but or in a minute. But Mr. Watson, if you join in this, your client has no answer because this replaces the previous answer. And this is not on behalf of your client.
Specific. The only thing that we are joining is the request that the affirmative defense be asserted. As I understand it now, plaintiff has waived the negligence claim against us. So really, it's just the vicarious liability issue.
Yeah, but if I grant this motion and this replaces the answer, there is no answer on file for Marvin Collins.
Yeah, that's a fair point, Your Honor. Well, that's why I was saying to the extent we joined, it's simply to assert the affirmative defense, not to wipe out Marvin's prior answer. So just be to add that affirmative defense to his answer as it relates to Marvin.
Okay, but this is defendant Zaon Collins' motion to amend answer on order shortening time. So you want me not to amend the answer, but to allow the affirmative defense. Am I correct? So you're not joining in this, you're making your own motion, right?
Correct.
Okay,
What I'm looking for is my answer to stand for Marvin,
okay.
but to allow the assertion of the affirmative defense.
But how do I grant this one without wiping out your answer?
Yeah, that's a good question. I suppose if it's granted, we could file an answer that's consistent with all the admissions and denials that have previously been asserted. But then it gets dicey because we'd be answering to a cause of action that's no longer being asserted. Negligent entrustment, because that was the only cause of action that was actually asserted against him in the complaint.
I mean, I think you're correct in that you have to attach the amended pleading to your motion, which you always have to do. I can't grant a motion to amend without an amended pleading attached. But this creates a bit of a mess because if I grant it, Marvin's sitting here with no response of pleading. Okay, plaintiff's counsel, what's your response to this? Have you had a chance? Well, let me start here. Have you had a chance to review it?
Just briefly, Your Honor, so I guess my first question is, Are you going to be ruling on this now, or are you gonna be delaying on this, just like the other, since there's gonna be comparative? The jury is gonna have comparative on the verdict form.
Yeah,
Are you gonna delay on this one too, so we have time to brief it? Because otherwise, I mean, obviously, we didn't.
so
unless-
you would request that I delay on this one? too,
Please,
right?
yes, Your Honor.
It would seem appropriate for us to roll our briefing together, or at least to file papers together.
Okay.
To the extent it's necessary.
In light of the issue I just brought up, I think delaying is appropriate so that I'm not leaving, if I was inclined to grant this, I'm not leaving one party that's sat here through trial. And I think he's actually been here through the most of the trial as far as the defendants go, not making any kind of dig at him, but he's been here a long time, okay? I mean, it's not making any kind of dig at anybody who hasn't, but he's been here through the whole thing. I don't want to leave him with no responsive pleading. And I understand why you didn't do it on behalf of him, Miss Zinna, because you don't represent him anymore. So I get the circumstance. So
In Your Honor, I think the way that you're planning on handling this or what's being discussed actually works, because then we could file a joinder and have our own answer on behalf of.
I think that might be appropriate. Okay, and technically this hasn't been filed yet anyway. I don't know if your office did file it when I kicked it back, but I just kicked it back. So I did look at it last night and I meant to bring it up, and then we got talking about other things. So I
I was just trying to be as procedurally proper as
Yeah.
I could. So that was the only intention, so I don't have a problem delaying it and just doing a straight filing and giving Mr. Watson the opportunity to file the joiner with his proposed amended answer as well.
Okay, so let's do that. So any argument, response, etc. on this one is delayed at this time or deferred. And defense counsel, if you still want to pursue this, file it and it'll just be heard after we're done with the trial. Okay?
The only record I wanted to make is we're still not consenting to the affirmative defense of comparative negligence. And we want to say we're not waiving our rights on that. And I think Your Honor and defense counsel all agree that we're not waiving our rights. Is that correct? Defense counsel?
Correct.
That's correct.
That is what I understand as well, that your intention was to assert your objection and your opposition here.
Thank you, Your Honor.
Okay, so let's get to any Rule 41 motions, I guess.
We would like to I'm not sure if you already ruled on this, so I apologize. Just want to make sure I bring it up.
Okay, better to
Under-
make the record.
Under NRS 41.440, there is no issue of fact. All the requirements under the statute have been satisfied. Mr. Collins, Zaon Collins and Marvin Collins are father and son. Marvin Collins owned the vehicle and Zaon Collins was a permissive user. Therefore, under the statute NRS 41.440, otherwise known as the family purpose doctrine in Nevada, there is no issue of fact. And if Your Honor grants that, we will be dismissing our negligent entrustment claim.
Hi, response.
Yeah, I actually think it was on the record from Wednesday. We do not disagree that the terms of NRS 41.440 are satisfied as relates to Marvin Collins. Obviously, we still maintain our constitutionality arguments, but as it relates to satisfying the requirements of that statute, we do agree that they're satisfied in this case.
So you do agree that if there's any liability found against Zaon, it can be imputed to Marvin via 41.440.
Yeah,
That's what you're asking, right?
Yes, Your Honor.
Subject to our constitutionality argument that we're preserving for appeal. Yes.
Okay. Okay, then I'm granting your motion. I believe.
Point of clarification, though, I do want that to be based on my assumption that we're including that instruction so the jury has an understanding of what's going on with Marvin. Otherwise, there'd be, and it's in your proposed, so.
Yes.
Yeah, so as long as we keep that in, so they actually have some understanding of what's going on, because otherwise they're completely in the dark, that he sat here the whole time, there were openings for him.
I would agree.
Yeah, okay.
And then in response, I would assume you would agree to take off the line item for negligent entrustment on the verdict form, since I'll be dismissing that now.
Correct.
Thank you.
We stipulate that.
Okay.
Any other Rule 41 or any other kind of motions that anybody wants to make at this time?
Not for plaintiff, Your Honor.
Yeah, sure. The damages category for Mr. Echevarria's funeral expenses was never entered into evidence. So we would move to exclude that from the verdict form.
Response.
Can
Sorry,
I
I'm gonna
check?
blow my nose, just give me a second. Excuse me, I'm sorry. Go ahead. Go ahead, Mr. Ladah or Mr. Chu.
We just have a second, Your Honor. I'm sorry.
Yeah,
We're just looking through the,
see if it's in there.
we want to see if it was pre-admitted.
Are you both doing that or one of you doing that? And I can make some, oh, actually, never mind. I'm gonna wait till you guys are done with these before I make some comments and ask some questions. Because I have questions about the verdict.
I have exhibit 6 as being admitted, Your Honor. When I went over it with the clerk yesterday, she said 1 through 29, 36, 37, 38, 39, 41 through 70, and 72. 1 through 29 would include exhibit 6. Exhibit 6 is the statement of funeral goods and services from Palm Southwest Mortuary.
Here, and our position would just be that there was no testimony for those damages. But I understand counsel's position.
The document was in evidence, right, by stipulation?
Yes, Your Honor.
It's in evidence, so you can both reference it in your closing. So, which exhibit is it exactly?
Exhibit 6, Your Honor.
Hold on. Oh. 'Cause I had that 6 got admitted on 5/7/25 with no objection. And 6 was. Is it a total of $8,823.65?
Correct.
So. To the extent it is in exhibit 6 or some other exhibit that is already in evidence or some testimony that's already in evidence, I'm gonna permit it. Anything else?
Yeah, sure. I'd like to make a motion for a directed verdict on the punitive damages claim. The punitive damages, as testified to the toxicologist, he could not meet a burden that was higher than more probable than not. And by his own testimony, could not meet the clear and convincing standard that would have been required for the punitive damages in this matter. Plaintiff has only alleged punitive damages as it relates to the alleged marijuana issue. There were no punitive damages, just in a general sense alleged in the amendment.
Response.
2 things, Your Honor. First of all, as far as the marijuana,
Let me get the amended complaint actually open. Just give me like 30 seconds. I have it open. I just need to find which document it is.
tell me when you're ready, Your Honor.
Might have to pull it up again. And I thought I had open, but I'm only finding the original complaint and not the amended one. So give me just a second. But you can go ahead and start talking while I'm working on it.
Okay,
I'll listen.
and Mr. Chu does want to talk about this a little bit, but I want to start, the first is, as far as the marijuana statute. Under NRS 484C.110, it is a per se requirement. And if someone is over the level, they are per se violating the statute. NRS 42.010 subsection 1 says in an action for breach of obligation where the defendant caused an injury by operation of a motor vehicle in violation of NRS 484C.110. They may recover damages for the sake of example and by way of punishing the defendant. The statute actually doesn't say they have to be
impaired, Your Honor. It only says they have to be over the limit and be violating and causing injury by operation of a motor vehicle. So the toxicologist said it was a fact that Mr. Collins was over the limit per se. The issue was that defense counsel is bringing up is what standard at which he could say he was impaired. So he said to a reasonable degree of medical probability, or more likely than not, he could say he was impaired. But he said the level to which he could say he was over the per se limit, it was a fact. And I think he said it was like over 99% probability because there's a tiny little error rate. He talked about the bell curve and he said the error rate is like 0.0 something. But perhaps Mr. Chu recalls that testimony better than I do. But secondly, Your Honor, I believe, and if you give me a second, I believe the punitive damages wasn't just based off of the,
I'm looking at paragraphs 25,
right?
or paragraph 25, I think, mainly. And 24. 24 states at all times relevant here too, in particular on December 30th, 2020, defendant Zaon Collins caused the death of Eric Echevarria by the operation of a motor vehicle in violation of 484C110 after willfully consuming alcohol, marijuana, or some other intoxicating substance. Knowing that he would thereafter operate the motor vehicle, he crashed into the decedent's vehicle at an excessive and reckless rate of speed. 25. And as a result of defendant driver's conduct complained of herein, in particular driving under the influence of an intoxicating substance, that in addition to compensatory damages, defendant Zaon Collins is liable to plaintiff for punitive pursuant to section 42010 for the sake of example and by way of punishing said defendant for his conscious disregard for the safety rules identified under NRS chapter 484B and willful and or reckless disregard of such safety rules.
484B, Your Honor, for the record, is the rules of the road, which includes the speeding. And I think going 88 and a 35 is sufficient for conscious disregard for the safety of the public, which is the standard under punitive damages.
Okay. Any response, counsel?
Yes, so just to address that last bit, the amended complaint clearly referenced the 42010, which is the statute that talks about exemplary or punitive damages for a violation of NRS 484C.110. It does not reference anything else in the NRS 42 realm for malicious or just general malicious or conscious disregard conduct. And the way that I would read this paragraph, he is seeking punitive damages for an alleged violation of NRS is the per se limit that is in 484C.110, because that is what the entire section reads, and then references 42.010, which is the statute that references 48C.110 as a basis therefore. So then turning to 42010, it states that it must be shown that there was willful consumption or using of alcohol or another substance. And that would have to been proven to a clear and convincing standard. And I don't believe that that happened here, nor do I believe that the toxicologist testified that he could ever meet a clear and convincing standard for any sort of intoxication or consumption.
Okay. I think there's enough here for this to go to the jury. We've got a documented speed. Although this complaint maybe could have been phrased a little more clearly, I don't think it's required in the state of Nevada to do so. And if defense counsel felt like they weren't on notice of what the potential claim was here, they could have asked for clarification before now. The speed of 88 miles per hour. I think everybody's said it that took the stand that had knowledge, including the defendant. Additionally, there is test results from, I believe, defendant's blood. I think that's the sample that was taken blood. It wasn't any other kind of fluid, right? Was it blood? Okay, so we've got the blood sample too taken. I think you can make the argument that that doesn't meet the clear and convincing to the jury, but it's enough that it goes to the jury for consideration and doesn't get excluded, or that claim doesn't get excluded via a motion at this stage. Anything else you want to say, since I'm not granting your request?
Not at this time, Your Honor.
Okay. Anybody else want to make any additional motions or record before I ask some questions and we get into the jury instructions?
No, Your Honor.
No, Your Honor.
Okay, so I want to start with the verdict forms because that's where, well, we just got into some of it. And both of your verdict forms, if I'm holding the correct most recent versions, which I'm holding defendants, although I don't have one from Marvin Collins at all. But I'm holding Zaon Collins's proposed special verdict form and plaintiff's proposed special verdict form. Zaon Collins's was filed on May 15th at 11:33 a.m. Plaintiff's was filed on May 16th at 8:37 a.m. Is there a more recent verdict form that I should be looking at, or are these the most recent ones?
That is the most recent for plaintiff, Your Honor.
Okay,
I, sorry, I don't have defenses in front of me.
you want me to
Thank you.
print it?
Got it.
Appreciate it.
Okay, you gave him a copy?
I did.
Thank you.
Okay, so are these the most recent verdict forms from from Miss Zinna?
Yes.
Okay, and Mr. Watson, did you propose a verdict form?
We do not, Your Honor.
Okay. Are you joining in the proposal of either of these verdict forms?
Yes, in Zaon Collins.
Okay, so here's my initial question. These all start with liability. I'm wondering why the question of, do you find by preponderance of evidence that Zaon Collins was negligent? I thought he said repeatedly through this trial that he was negligent. So why do both start with that question?
Honestly, I don't think I've seen, even when we have comparative fault. I don't know how else we would set it up for them to understand how to get to the next question,
I mean,
but I'm open to suggestions.
I mean, here's the problem. We've had him take the stand and say, yes, yes, yes. What if they check no? Then, like,
the other option is we could have 1 and 2 already checked yes. I mean,
why isn't it that there was, that he's accepted some liability or something like that? Like whatever the phrase should be based on what he did. But we also could just get to using 100% as the total combined negligence, allocate percentage of the total combined negligence. We could start with question number 4.
we wouldn't approve, we think that's improper, Your Honor.
And I think we need to lay it
The
out.
reason that's improper, Your Honor, I'm sorry, if I can just finish. The reason that's improper, Your Honor, is because they have to find by preponderance of evidence that Mr. Echevarria's negligence was a cause of the crash. And if they say it was not the cause of the crash, then they don't get to the split up of liability. And that's gonna be a big issue with the defendants.
Okay, so 3 needs to be on here no matter what. I know what
Right.
you're saying. But 1, is that the way we want to phrase it when what we've put on indicates that he kept saying he's accepting liability. I don't know if he actually said, yes, I was negligent, but I got the impression that's what he meant.
He said, I'm accepting my responsibility for my part in this accident. Those were the words. And so I don't think it's really, if we're being honest, I doubt the jury is going to get confused. I think they're gonna be able to say, if we take off Marvin out of here, if it's, do you find by a preponderance of the evidence that Zaon was negligent? Do you find that Eric Echevarria was negligent?
Okay, Marvin comes off, right?
Right, Marvin
Yes.
comes off. Yeah.
Okay.
So those 2 questions, I think, don't muddy the waters to the degree, and then I think it's confusing if we say, well, Zaon accepted, responsibility, so we don't have a question as to Zaon, but we do have one for Eric. I just think it's easier, it's cleaner to have questions 1 and 2, and I don't think it's really, I don't think it's too difficult for the jury to understand. I would be shocked if they hit no any of this, so.
And Your Honor, with defense counsel's verdict form, assuming that's what you're looking at. The
I'm
first
looking at
thing,
both next to each other.
the problem that theirs is it doesn't have whether or not the negligence was a cause of the death. And that has to be on there because they can't just be negligent. Someone can be negligent and it cannot be the cause of someone's injuries or death. So
Why aren't we just starting with question 2 then? Do you find by a preponderance of evidence that Zaon Collins' negligence was a proximate cause of Eric Echevarria's death?
I'm fine with that.
Sorry, you have the other form in front of you too?
I
Or
do.
no?
Yeah,
I mean, I think the easier thing to do, just to make it clean, it would be to automatically already have a check mark under yes in question number 1, so they follow what's going on here as far as Zaon Collins' negligence. Zaon Collins' negligence was the cause. Eric Echevarria's negligence was the cause. Does that make sense, Your Honor?
What are your thoughts on that? On there already being a check in the yes box?
I don't think I don't like filling in a verdict form, right? Like that is within the province of the jury to fill it in. I don't think it hurts anything or confuses anything if we just have the same questions laid out for each one. I would also say that if we're going to do you find that the negligence was a proximate cause? I did take a look at Your Honor's concern with proximate versus legal cause, and I think legal cause is the actual appropriate instruction here. So I think we need to, because of the substantial factor test, I think we need to change the proximate language to legal cause. And then if we took plaintiff's form and did, do you find by a preponderance of the evidence, Zaon, do you find by a preponderance of the evidence, it was a legal cause? Do you find by a preponderance that Eric was negligent? Do you find by a preponderance that his negligence was a legal cause of his own death? And then we move on to, and I thought we were going to, because we were going to wait for the comparative contributory negligence aspect of this to be kind of situated after trial. We were going to skip the whole, if you answered yes or no, skip ahead, and we were just gonna have them answer 5 without that direction.
Well, they can't answer 5 if they answer no to number 4. Because if they answer no to whether Eric Echevarria's negligence was the cause of his own death, then they don't get to the percentages because it's not the cause of his death, so it can't be allocated in a percentage. Does that make sense?
Wait, okay, repeat what you just said.
So if they answer no to number 4, question number 4 on
You're
my
going off of yours right now, right?
yes,
Okay.
my number 4 on my verdict form
You
is
find by a preponderance of evidence, Eric Echevarria's negligence was a either legal or proximate cause of his own death.
yeah. If they say no to that, they don't then go and put a percentage in Eric because they've already said it's not the cause of the death, and therefore there can't be a percentage allocated to Eric Echevarria.
What if the workaround is if you mark no to this, places 0 in the next question for Eric? So if you mark no, places 0 in the apportionment.
They mark no, isn't the right thing just to skip the next section?
Yeah, I don't understand why they would put 0 because there's no allocation, so they're skipping it because they're already saying no. I don't understand.
But if
why.
they mark no to 3, they skip all the way down to 5 anyway. I mean, they
Correct.
skip all the way down to 6.
Correct.
Sorry, I'm just trying to think what the simplest way of putting this in front of them is. Because if we're having this kind of discussion about it.
I mean, if you look at the top of page 2 of mine, I have directions for them. If you answered no to either question 3 or 4 above, then skip question 5 below and proceed to answer question 6 below. If you answered
Well,
yes,
shouldn't that direction be above 3 though? Because what if they click, what if they check yes on one and no on the other?
that's fine. I have no problem with it going somewhere else.
As long as they do yes on 3 and no on 4, it's okay to keep going. But if they've done it the other way around, they can't. Well, no, even then it's not okay to keep going.
You're saying if they say no to 3, then they don't even have to answer 4.
Yeah,
Yeah,
if
I
they say
agree.
no to 3, you skip 4 and 5.
I agree. That makes sense.
That makes, yeah, it makes more sense to put it there.
to put it above it, right?
I'm fine with that,
Okay,
Your
I
Honor.
think the directions, and this is your form, so how about you revise your form? Let's work off the plaintiff's form. And we will add what we need to from defense form into plaintiff's form as we go. Okay, just because plaintiff's form is longer to begin with. So both of you want that first question. Do you find by preponderance of evidence that Zaon Collins was negligent? You're both fine with that question going to the jury.
Which question, I'm sorry?
Do you find by preponderance of evidence that Zaon Collins was negligent? Question number one off your form. You're both fine with that going to the jury.
I thought you said you were,
I don't like it, but at the same time, this isn't my trial. This is your trial, so, and you're as in, you guys counsel are trying this case. So I understand the argument from both of you that you're saying you're just gonna have them check yes there. But, if you have an alternative for that one, because my worry would be that they check no and then keep going. Or that they check no, and I'm not sure that can be construed as being consistent with the evidence that we've heard.
I'm fine with it going to the jury, Your Honor. Number one, question number one,
Number one.
Okay.
even if it's not filled out, perfectly
Okay,
fine.
so number one, we'll leave. Number two, do you find by preponderance of the evidence that Zaon Collins was, and there's an issue of whether we're gonna use legal or proximate cause, right?
Right.
Okay, so I'm gonna pull up the instructions. I thought when I read the instructions, as I understood everybody's arguments that they were gonna make, that legal was probably more appropriate for this case. But it is as I sit here now, I think plaintiff does not agree with me, right?
I don't agree, Your Honor, but I don't know that it makes a difference. If you give me a second.
Yeah, look at 4.4. I'm pulling it up too right now. I had it printed out, but I don't know where it went. 4.4 and 4.5, I believe, are the instructions. And read the use notes. And I believe they're referring to them as, hold on. They're referring to them as the but for and substantial factor.
Yeah, so in my proposed set, I used 4.5 and 4.6 in lieu of the proximate cause instruction.
Okay, what's 4.6? Can I look at that? 4.6.
4.6 is that there may be more than one proximate or legal, whichever one word you use, cause of an injury when negligent conduct of two or more persons contributes concurrently as a proximate or legal, whichever one chooses, cause of an injury. The conduct of each said person is a proximate legal cause of the injury, regardless of the extent to which each contributes to the injury.
I don't believe this is appropriate, Your Honor. This is for if there's a car crash and three different cars crash together, or there's two different defendants. It's not a situation where you have plaintiff.
Well, I guess here's my question. Could this accident have been caused by actions of both the plaintiff, the decedent plaintiff and the defendant, or could it not have been?
It is our position that it was caused in part by both.
That's what the comparative instructions are for. I mean, and that's, Mr. Ladah's right. These are for circumstances where there's.
Well, the second paragraph is dealing with if there's two accidents, right?
That's true, but I don't think you can split off an instruction, give half of it and not the other half, because that part of it is not bracketed.
I think 4.6 might be for, I mean, it does say concurring causes, but at the same time, I think 4.5, a legal cause of injury, damage, harm, or loss or harm is a cause that is a substantial factor in bringing about the injury, damage, loss, or harm.
Are you requesting to put in the bracketed language too, counsel?
For 4.5, I can leave that out.
And if we do 4.5 without the bracketed language, are you saying we don't need 4.6? Because I'd rather it just be simple. That makes sense.
Yeah, that's fine. If we just do 4.5 without the bracketed, we take out the proximate cause instruction. We do 4.5 instead without the bracketed, we scrap 4.6, I'd be fine.
What are your thoughts on that, council?
Court's indulgence for
Yeah,
20
take a
seconds,
minute.
please.
I didn't hear everything that was said, but if you guys agree, as long as it's consistent with the law, I'm gonna let you do it.
Okay, I mean, are you okay with the bracketed language? We may not be opposed to the bracketed language.
Hold on, let me pull it back up.
Are you
Someone
okay
wants
with?
the bracketed language, I'm probably gonna be inclined to include the bracketed language, because I do think it's an appropriate part of this instruction.
Okay,
That's just my thought on it, unless you guys like both agree to keep it out. If one of you want it, I think you should put it in, especially because I don't think we are putting in 4.6, and I'm not sure 4.6 would be appropriate, because we don't have concurrent, we have simultaneous, right?
we're
I-
okay. Sorry, go ahead.
Oh, go ahead.
I was gonna say, we're okay with 4.5 with the bracketed language, as long as we don't have 4.6. It's confusing.
Agreed.
Okay, so we're gonna do 4.5 with the bracketed language, and we're not gonna do 4.4, right?
Correct, Your
We
Honor.
can't give approximate, I don't think it's appropriate to be approximate and legal. Okay, so we'll give the legal, so the verdict form, going back to the verdict form, it's gonna say. Question 2, do you find by a preponderance of the evidence that Zaon Collins' negligence was a legal cause of Eric Echevarria's death? Do you find by a preponderance, the next question, number 3, do you find by a preponderance of evidence that Eric Echevarria was negligent? Yes or no? No, yes or no, excuse me. 4, do you find by a preponderance of evidence Eric Echevarria's negligence was a legal, not proximate, cause of his own death? Yes or no? And then this paragraph, I think we should put it above number 3, where it says if you answer no to either question 3 or 4 below, we'll put it above, then skip to question 5 below and proceed to answer, then skip question 5 and proceed to answer question 6. If you answered yes to both question 3 and
I got
4 above, then proceed to answer both question 5. I think that blurb should go above 3. I thought it was actually above 3 in the forms. Is it not anymore? Did they revise the forms?
To be honest, I don't know. Your Honor.
Okay.
And just for my own clarification, then so plaintiff's instruction on proximate cause at page 50 of their set, we're going to strike in favor of using 4.5 full instruction with the bracketed language, but not using 4.6.
That's what I understood just happened.
That's my understanding as well.
Wonderful.
Correct.
Let me see if the new stuff even has the forms. Yeah, it does have the forms.
So the language, just to make sure we're clear, it says,
I'm gonna go back up to
you
here.
wanna read it for the judge, just make sure?
Yeah. Judge, can I read you the revised verdict form with the instructions?
Yes, please.
Okay, so. Question 1, do you find by a preponderance of the evidence that Zaon Collins was negligent? Do you find by a preponderance of the evidence that Zaon Collins' negligence was a legal cause of Eric Echevarria's death? 3, do you find by a preponderance of the evidence that Eric Echevarria was negligent? Instruction, if you answered no to question 3 above, then skip questions 4 and 5 below and proceed to answer question 6 below. If you answered yes to question 3 above, then proceed to answer questions 4, 5, and 6.
Okay.
Well, it's not questions 4, 5, and 6, because if they answer.
Okay, then question 4, I guess.
Question 4
Okay,
below.
Okay,
And then you're gonna put another instruction below 4?
correct, and I have that, so, and then, sorry.
Because if they say no to 4, we can't have them fill out the
5.
numbers.
Question 4, do you find by a preponderance of the evidence Eric Echevarria's negligence was a legal cause of his own death? Instruction, if you answered no to question 4 above, then skip question 5 below and proceed to answer question 6 below. If you answered yes to question 4 above, then proceed to answer questions 5 and 6 below.
Okay, that sounds correct to me.
Yeah, and obviously you can take a look at it once we get it worked out, and then obviously council can.
So yeah, if you want to draft that up, if you're not already drafting it, then yes, put that together and we'll print it out and show it to everybody before we absolutely finalize it. Okay, so moving on then, we don't have any, up to this point, we're all on the same page, right?
I believe so.
Okay, so let's go to 5. Using 100% as the total combined negligence, allocate the percentage of the total combined negligence that you find attributable to Eric Echevarria's death. Percentages must total 100%. So, defendant's proposed form had Marvin Collins on it. There's no problem taking Marvin Collins off, right? Okay, so, and no problem with plaintiff's proposed question 5, right?
No.
Okay, 6, what amounts of damages do you award and Marie Echevarria and Eric Echevarria Jr.? That language is exactly the same, I think. The next part is where maybe we have a couple of word differences. Maybe, I'm not even sure if we do.
So the primary difference is, from our perspective, council has placed the categories spelled out into 6 different lines of categories for damages and has separated out the pain and suffering, the grief, sorrow, all of the categories of damages for the 41085 for the date of the loss to the present, and then another line for the future. And then same thing for Eric Echevarria on both of those. They didn't parse out that with the economist. The economist just gave a lump sum from whenever going forward, and I think it gets confusing to have multiple lines like that. So I had put just more in line with the statute itself and in line with the economist's testimony that was not portioned out. That it just be one line for each of those categories that's enumerated in 41085.
Okay, do you guys want to respond? Here's my concern. Okay, I'm sorry to cut you off. I asked you to respond and then I cut you off. Go ahead, sorry.
No, go ahead, Your Honor.
If they put numbers here on the defense side, you pay interest on all of this. But on the plaintiff side, you're only gonna pay interest on the lines that are for past, right? Am I missing something?
Well, you're right, Your Honor. Interest for past damages is different than interest for future damages. So past damages goes back to the time of filing the complaint. Future damages would just be from the time of the judgment, or sorry, the time of the verdict in perpetuity going forward until they pay it.
So that's my initial question about the defense form.
Yeah, and that's a valid concern.
Now, if plaintiff was the one proposing this, then I would be asking plaintiff, like, well, I might not say anything, but I would assume that you were waiving the past interest, because like, but this is defense proposed form, so I think if we use this form and it gets awarded, interest leans in your favor with going all the way back on everything to the date of the filing. But, so you're okay with the plaintiff's way of putting it?
Yeah, I guess it's gonna, and it does, yeah, it's probably the better way to track the.
Okay, so we have no problem with number 6 then either. Well, number 6 up to D at this point.
Up to D at this point, I believe.
We haven't talked about the medical expenses
Yeah,
and,
that's fine.
okay.
And I don't have a problem with the medical expenses or funeral expenses.
Okay, so we have no problem that we haven't addressed on any of number 6 on plaintiff's form.
Correct.
Okay, then the final part. Excuse me, does the jury find by clear and convincing evidence that punitive damages should be assessed against defendant Zaon Collins? On behalf of Eric, okay, so the only difference I see is the extra language on behalf of Eric Echevarria Senior. I don't know if that's even an accurate representation because of the plaintiffs are all I mean, the plaintiffs are more than that, right? So,
The estate and the heirs. Let's see, where did I put it?
yeah.
Put theirs.
So we either need to correct the language or add to plaintiff's form the full plaintiff list. Or have nobody listed and have it like this, where I think it's obvious whatever they're awarding is on behalf is going toward the plaintiffs? Like, is there,
I think it's simpler just to leave it at against defendant Zaon Collins. I think it makes it a little confusing if we start to put plaintiffs in there. This is not this is not the number as to what they're awarding in punitives, it's just yes or no.
We agree with the judge's belief that it's obvious as to who it's coming from.
that's the only difference I'm seeing, right? On behalf of Eric Echevarria Senior, that's
Yes, sir.
added to the defense form.
Yes. And I think the statute is, and let me back up a little bit too, because I think the damages for the medical expenses and the funeral expenses also need senior behind it. And I think that
Oh, okay.
it needs to enumerate on behalf of Eric Echevarria Senior, because that's what the statute is. It's not for the heirs. It's for the personal representative on behalf of the decedent that punitive damages would apply. It is not to Anne Marie and Junior. So I think it does need to be clarified.
We're happy to put it in as senior, every place where he wasn't referred to senior. So
Okay, so you
add
put
that.
in the seniors on E and F.
Yes,
And then, so their issue with the next question, does the jury find by clear and convincing evidence? Which. Okay, should that be number 7? Or is it purposefully not numbered because technically it's,
Yeah, I did not number it in mine.
no, neither did they. I'll leave it unnumbered if you guys want. Yeah, that's fine.
I don't think it needs to be numbered because it's just I
Okay.
don't think so.
Well, the personal representative of Eric is Anne Marie Echevarria, right?
Correct, Your Honor. He's the personal representative of the estate.
And the statute is the damages recoverable by the personal representative of a decedent on behalf of the estate include punitive damages. So it needs to be clear that Anne Marie and Eric Junior don't get punitive damages in their individual capacity.
So Anne Marie Echevarria as personal representative of the estate of Eric Echevarria.
That would be fine, or just leaving it on behalf of the decedent, Eric Echevarria Senior is fine by me. It just needs to clarify that they don't all they're not all entitled to punitive damages.
Yeah, we're okay with saying on behalf of the estate of Eric Echevarria.
Okay, so why don't you put the language in since we're working off of your form and show it to defense?
Are you saying you want to exclude the language about Anne Marie there and just say on behalf of the estate of Eric?
Yes, I think it's simpler.
Yeah, it's less cumbersome language. I
Okay,
think that's fine.
that was a good word, cumbersome.
Every once in a while.
I used that on the record at some point in the last 2 weeks. I don't remember when, so, yeah.
Sorry,
I
we are-
received no credit.
We are at the record, so
I know.
I'm trying to choke you.
No jokes on the record.
Unless we're talking about Brad. Senior. Okay.
All right,
Do you want me just to email this whole thing to you, Stephanie? And
What?
should we just email you and defense counsel the form?
The email to defense counsel, let her look at it if, and him. If they look at it and they have no problem with it, then you can go ahead and send it to me and I can make copies for everybody to leave here with if you would like. And
Sounds
I
good.
can. Finish early, we can all head over to City Hall and see all the new attorneys get sworn in. No.
Is that what they
I
do?
cried at the last ceremony. I couldn't help it.
Heather, what's your, oh wait, I got it.
Is that the right verdict form?
No, I'm asking.
I don't know. Yeah, that's him.
All right, SJW, is that right? All right.
That's the one.
All right, I just sent it to you guys with there's nothing in the subject line. We got sworn in, it was like it's like it was at the Rio,
Sorry, can I run to the restroom real quick?
Yeah, go ahead.
Apologize.
not quite as classy.
Judge Gonzalez.
Yeah,
told
let's
me.
pause it.
Though.
I was one of
On the
those.
special.
No, because she came to Albertson Taylor and swore us in.
Well, no, I actually came down here because I
Oh.
asked her for her.
They brought her into Albertson Taylor
Yeah.
when I was there.
When I
all
said
this
they
got
did,
sworn in the basement and they had this like, the
Yep.
cake was like the size of the table.
that creepy basement. Yeah,
Yeah,
they,
that's where the Christmas party was too.
yeah.
I don't think I would stay long enough for a Christmas party. I think I took my bar dues check. It was, thank you.